Section 2 is titled Core Compliance Policies and Procedures. This section applies to everyone. Section 2.1 Duty to report potential compliance violations and anti-retaliation policy. APT Management requires employees to promptly report any known or suspected violations of the Code of Conduct, compliance program or any of the laws, rules and regulations by which the company is governed. There are 4 ways to report compliance issues. Reporting to supervisors or managers. Reporting to the compliance officer. Reporting to a member of the compliance committee. Reporting to the compliance hotline at 855-806-4296. The non-retaliation non-retribution policy states that there will be no disciplinary or retaliatory actions against individuals who report issues in good faith. Good faith means the individual believes the potential violation actually occurred as he or she is reporting it. This would not include intentionally falsifying a report. The non-retaliation non-retribution policy does not allow employees to avoid punishment for reporting their own violations. However, self-reporting may be taken into account when determining disciplinary actions. Employees who believe they have been retaliated against for reporting violations should report the retaliation as soon as possible to their supervisor, clinic director, compliance officer, a member of the compliance committee, or the compliance hotline. The report should include a thorough account of the incident and including the date, time, locations and names of any witnesses. Section 2.2 Documentation of compliance activities goes over the job duties of the compliance officer. It explains how compliance complaints, investigations and training materials are documented and contains a sample compliance log at the end. Section 2.3 Credentialing of licensed therapists. All clinicians are required to be credentialed and licensed in compliance with state and federal laws. They must keep their license in good standing with the jurisdictions in which they practice, and provide proof of their license to HRN or the billing department for credentialing and contracting. It's the clinician's responsibility to renew their license and meet all continuing education requirements. MedBridge is provided for therapists and a great source to meet continuing education requirements. For Medicare licensure, clinicians will work with a billing director to complete applications and reassign their benefits under the company. Section 2.4 Exclusion and background checks. It is company policy not to employ, contract or otherwise do business with any individual or entity excluded or ineligible to participate with federal or state-sponsored healthcare programs, including Medicare and TRICARE. Background checks are performed prior to individuals' employment and monthly exclusion checks are performed with the OIG's website. Section 2.5 Responding to government inquiries and investigations. This is a very important section that needs to be read by everybody. There is a quick reference guide found at the end of the section that I'll go over. It is company policy to fully cooperate with reasonable requests of government officials. If at any time an investigative demand letter, subpoena, or search warrant is received by an employee, the individual must immediately notify the compliance officer. If the compliance officer cannot be reached, the individual must immediately notify the president's directors by calling the HR admin office at 410-553-9686. The compliance officer or someone from the compliance committee will coordinate the company's response. Employees or independent contractors should not release or copy documents in connection with or in response to an investigative demand letter, subpoena or search warrant without the authorization of the compliance officer. No employee may remove, alter, create or destroy documents or records including but not limited to paper or electronic records, in anticipation of or during an investigation. If an investigator or other government representative appears in person, employees should request a C identification and business card or a badge. A staff member should then call the government representative's office to confirm their identity and authority. Staff should provide this information to the compliance officer as soon as possible. A search of company premises may not be conducted without a search warrant. A search warrant is a document permitting government agents to search and seize property described in the warrant. If an official shows up with a search warrant, you should ask for a copy or permission to make a copy and immediately provide to the compliance officer. Once a valid search warrant is provided, APT Management employees may not stop the search. While the search is being conducted, a staff member, ideally a supervisor, needs to be appointed to communicate with the government representative and keep a detailed list of all documents seized or copied. Detailed notes must also be kept of all records inspected but not seized, and note any conversations between government representatives and employees. If any records are seized, the staff member in charge should request that the records be copied first. If they do not allow you to make copies, call the compliance officer. If they request to seize computers, ask if you can copy all files first. Employees are required to answer questions concerning the location of documents, but they do not have to answer any other questions. You may tell the government official that you prefer to wait until you have counsel present before answering questions. If you are asked to sign an affidavit of any kind, explain that you are not authorized to sign any document prior to review by APT Management's legal counsel. If you are asked to consent to an interview, you have the right to schedule the interview at a later time, and you also have the right to decline the interview. Employees are entitled to have a company representative present with them during an interview, and the company will arrange to have the company's attorney present during questioning at no cost to employees. The quick reference guide highlights everything you should know when responding to government inquiries. They are: anytime a government agent comes to an APT location or APT receives a subpoena or demand letter, immediately contact your supervisor or manager and the corporate compliance officer. When a government agent arrives at a APT, always be courteous and truthful. Ask to see the government agent's identification and business card, and call the agent's office listed on the card and confirm the agent's authority. Make a copy of the agent's documentation, for example, search warrant, subpoena, demand letter. Under no circumstances are you ever to alter or destroy documents that are the subject of the investigation inquiry. If the government agent asks to remove items from the premises, ask to make copies first and keep a thorough list of everything the agent removes from the premises. If you are asked to sign an affidavit of any kind, do not comment as to the validity of its contents, and explain that you are not authorized to sign any document prior to review by APT's legal counsel. If a government agent asks to speak with you, you have the right to request that the agent schedule an interview at a later time. And you may have someone, that is, an attorney, with you during the interview. When you speak to a government agent, always tell the truth. Keep the corporate compliance officer informed at every step of the investigation inquiry. Also, do not discuss the investigation inquiry with anyone without first receiving permission from the corporate compliance officer and/or legal counsel. Section 2.6 Fraud and Abuse Prevention. This section reiterates the company's commitment to comply with all state and federal laws. We only bill for medically necessary services provided to patients. Any errors in procedures or units billed need to be corrected and brought to the attention of the billing department, so corrective claims can be submitted and refunds issued for any overpayments. Section 2.7 Discipline and Incentive Program. Employees found to have committed violations of the Code of Conduct, Compliance Program or state and federal laws will be subject to appropriate disciplinary action up to and including termination of employment or contractual relationship. Examples of violations resulting in disciplinary action include: failure to report actual or suspected compliance violations by a peer, manager or subordinate. Failure to cooperate with an in-house investigation. Retaliation against an individual for reporting an actual or suspected compliance violation. Failure to act in an honest, reliable and trustworthy manner when conducting company business. Factors that may be considered when determining disciplinary actions are: whether the violation was committed knowingly, whether an individual leader was dishonest during the investigation, patterns of misconduct, if an attempt was made to cover up violations, whether the violation involved retaliation against others who reported violations in good faith, whether the violation was broke state or federal law, whether the individual personally benefited from the violation, if the violation was voluntarily reported. Damages. Disciplinary actions are equal for everyone and similar punishments for similar offenses will be handed out. There isn't much of an incentive program for reporting violations of the compliance program, but this can be considered in performance reviews that individuals are looking out for the company. Section 2.8 Auditing and Monitoring. This section explains additional duties of the compliance officer that includes clinic visits and auditing of therapy notes. The compliance officer might pop in the clinic to verify patient records are stored properly and procedures are being followed. Section 2.9 Conducting Compliance Investigations and Corrective Actions. This section discusses again how to report compliance violations and how investigations will be conducted. To investigate compliance violations, the compliance officer might review documents or have to schedule interviews with employees. It's possible reported concerns might be redirected to HR or outside counsel. In response to reported violations, employees may be assigned to other departments or managers to avoid an uncomfortable work environment. A corrective action plan shall be developed when needed.